This is The Roadmap with Ted Jenkins.
Hey everybody, welcome to The Roadmap. I'm Ted Jenkins and you're watching the Atlanta Small Business Network. Every week we talk to founders and CEOs and entrepreneurs all about this idea of climbing the ladder, of scaling your business, and one day you too could exit stage left and monetize your business for a lot of money. I'm super excited about this interview today because I've got Robert Benson, who's a partner at King Spalding. And I thought that this would be a really interesting interview for us today because now we're going to talk about what really matters, the legal documents. But before we do that, I just want to know, did you just wake up one day and say, I want to practice law? You're at one of the best law firms in the country, on the planet. Did you say I wanted to get into doing M&A as being an attorney?
No, it happened over time. I started out thinking I wanted to do economic development for the poor, moved into working in business incubators and working with entrepreneurs, and realized I wanted more skills to be able to help those folks because they were doing really exciting things. And so I decided to go to law school, got my JD MBA at Harvard, and then...
Well, that's a terrible school. Terrible school.
Well, I had a great time there and set me up well. So I moved into practicing law at Cravath Swaine Moore in New York, had my own practice for a bit, and now I'm at King Spalding.
Can you remember the first transaction that you ever did? Do you remember the first one that you ever did as a business attorney and doing these M&A transactions?
Wow. It was some sort of deal for AOL.
Really?
Yeah.
Okay, just a small company out
there.
there.
Yeah. I remember it was some deal. I can't remember what it was, but I just remember entering this room and they were in the process of due diligence.
Right.
And it was back before we did a lot of that stuff online. So we were actually looking through documents, like actual documents, and reading and summarizing them. And thankfully, technology has progressed since then.
So I have so much that I want to talk about today and unpack when it comes to be thinking about documents in terms of scaling and selling a business. But let me just start in sort of the beginning part of this, which is how important is the operating agreement that you set up for your business, whether you're a sole proprietor or you do this in a partnership. How important is that operating agreement when one day you sell the business down the road?
Well, that operating agreement, it sets the framework for who gets what when money comes in. And your buyer is going to look at that to know where the money's going to go, who they have to pay. And I would say it sort of is the roadmap as well for how you're managing the business to get to that point. And so I think it's a very important document.
Although for some people, it's just kind of a book that sits in the brown binder or whatever it is that you get. But it really does describe what happens if you have to dissolve the business or you have to break up with a partner. And a lot of people don't think about it. And doing just a boilerplate one, that's the wrong way to do it.
Yeah, I would think so. There are no key contracts for your business that you should do in a boilerplate fashion. If you have expectations to grow your business and to have it succeed and thrive, you need to know that the documents you prepared that govern that entity actually work. And so boilerplate isn't the way to go.
Do you, when you do the construct and you set up a business, and let's say you have two partners, sometimes those partners don't sign employment agreements with the company. Are you in favor that they actually sign employment agreements with the company, or do they just leave themselves as partners in the business, so to speak?
It really depends. I think it depends, one, on the way that you've organized your business. There's some business organization types or entity types for which that wouldn't be appropriate. And then it also depends on what your long-term goals are. Now, the good thing about it is that every agreement can be modified. So if going forward you figure out that you actually do need to do that and will protect you, you can change it.
You can change it along the way. How about on the other side of this? The business grows. Often owners want to do something for their employees. Do you recommend setting up a separate class of shares? Is that possible? Or doing what I've heard to be called phantom stock. I've actually done this in my companies before where you say, look, if this company sells, you're going to get something. Is there a better or best way to do this?
Yeah, well, I think the best way to do it is the way that makes sense for motivating and encouraging your employees to be invested and to retain them. In some case, and it also has to do with the structure of your business and what your investors think, right? So there are some scenarios where investors don't want many classes of stock, and so you've got to think about other ways to compensate your employees, or you may or may not want them to feel invested by actually having ownership. So some of those things you think through and you talk through with your attorney, and then we figure out what your goal is and your strategy. And there's always a way to
and that's a challenge, right? Because if you're taking on capital, you may still think you're the owner of the company, but when other people are in your wallet, that may affect the decisions on how you actually run the company. So if I'm bringing on investors today and I want to raise money, is that something I have to have a regulatory document? Some people who are watching this may have heard of something called a PPM. Do you need a regulatory document to raise money? Because there are some people that go online and they crowdfund or not.
So I would say in any case when you're raising money, you need materials that explain what your business is and what it's been doing. Now, depending on the type of audience that you're giving that to, there are different regulations and the type of company that you are. But I would say generally, if you have a document that clearly and truthfully explains who you are, where you've been, and where you're going, that's a good way to go. And then a lawyer can help you decide which regulations apply to you and the audience.
Right. It always starts out that paragraph that says, oh, by the way, you can lose all of your money. You take 100% risk. But people need to know that because a lot of businesses succeed, but many of them fail.
That's right.
I want to get into the meat of the end of the transaction because I've been through this myself. I have friends that have been through this. Let's just start with the process of an NDA. And so when you get into discussion with another firm about the potential acquisition of your business, you may not want the community to know. You may not want your employees to know. That's right. Is there a best way to do an NDA? Because I think sometimes people get those NDAs off the internet. Do you do a mutual NDA? What's the best way to do that?
Yeah, we like to do mutual NDAs.
NDAs.
Because sometimes you're trading information. And so depending on which side we're on, we like to protect our client, right? And so a lot of times if we're on the buy side, we'll say to them, listen, we might reveal information about us, and we want you to protect that. And then when we're on the sell side, obviously we want to protect the company's secrets. Now that doesn't always work, right? And that may not always be the best way to go about having a quick conversation if that's all you're doing.
But you're saying when it doesn't work, the question a lot of entrepreneurs ask is it really enforceable? You know, if I tell you I'm going to sell my company and there's an NDA and you say, yeah, I'm not going to tell the whole city of Atlanta that you're selling, and then it leaks out. Can you actually enforce that NDA?
You can certainly try, and that's the point of that's the point of doing it, right? It's a little bit more protection, right, before you reveal information. And I would say too, we stage the delivery of information, so you may enter.
What does that mean when you say you stage the delivery of information?
Yeah, so you will certainly be in touch with folks who are interested in your business and share things that are not, you aren't going to open the back cellar door and explain everything that's going on in your business until you see some progression in the actual negotiations. There will come a point where you will enter into exclusivity. And after you enter into exclusivity, you may feel more comfort opening the cellar door a little bit more and sharing a bit more about your business. But that's something that you stage as you go through the negotiation process. Because a lot of times negotiations end.
So when you look at this, eventually people get to that point that they get interviewed by a couple companies and vice versa. You go down this process, you show them the company, you may show them the financials, and then you get to this stage where you may get something called an IOI or an LOI, letter of interest or indication of interest. And I want you to explain to people, because I don't think a lot of owners understand that there will be a term in there called non-binding. So you may jump for joy and say, wow, this company offered me $20 million. What does that mean for folks that have never heard of that? They're thinking they might sell their business at some point. A non-binding LOI.
Non-binding really means that you can't take it to the court and enforce it, right? So what they are literally giving you is an indication of their interest. They'll put terms in there, and those terms will allow you to determine whether this is a good, opportunity relative to others that you may have received. But it's the starting point for negotiations. The real negotiation happens in the preparation and the determination of the definitive documentation. So the actual purchase.
That's when the real negotiation
That's when it happens. I will tell you though, that we often use the IOI and the LOI as the roadmap for that.
Sure.
And so you want it, when you do receive an IOI or an LOI, you do want to encourage the counterparty to put as much information in there as possible so that you can make a good decision about moving forward with the particular
because when you sign that, you legally are generally signing exclusivity, right? You're saying, if I was talking to 3 other potential buyers, that's off the table now once I sign that LOI. Is that accurate?
So that's right. So there can be parts of the letter that are binding and others that are non-binding. So
Right.
one part that's binding is typically the exclusivity portion. If you're doing an LOI and someone is saying, once we sign this document, we are no longer going to go shop and look for other opportunities. The other part may be the confidentiality section. So as we were talking about before, you may have in that LOI or IOI language saying that the two parties are not going to share their discussions with others. That would also be binding.
Yeah.
And then you can pick things like governing law and other things like that.
So, and that would be problematic, right? That leaks out, it could be bad for basically both the seller and the buyer. But then you start to go into this phase, if you might explain to people a little bit, of due diligence. Having been through this, I'm not going to quite say it's a doctor exam, but I will say it is very, very intense.
It is.
And it can last 60 to 90 days. What happens during that due diligence period?
Yeah, so during that period, the buyer, if you're looking to acquire, or the seller, you are sharing information about the business, and you're allowing the buyer to go in, sort of kick the tires and understand how the business works. That means you're looking at every single contract or material batch of contracts to understand the business. You're testing the financials to make sure that they reflect what
do
the
they
business
add up
looks
what
like.
they actually gave me, right?
Exactly. You're understanding whether there's litigation outstanding, tax issues, and we literally cover what we think is, a full survey of the business, trying to understand it. And that does two things. One, it makes sure that the buyer knows what they're getting. And two, it helps prepare the buyer for the day after closing, right? To get in and be able to run your business, because now they understand.
Yeah, because during that time, aren't they going to be looking at what you should have done legally, right? Your employment contracts.
Yeah.
They're going to be looking at vendor relationships, or if you have solicitor agreements. That's all part of the due diligence period, and why an owner, if you're really preparing to sell your business, you need to make sure all those documents are in place, because if somebody's going to pay you millions of dollars, they're going to say, I have to dot my I's and cross my T's, no?
Yep. And you will save yourself time and cost in the process by being organized on the front end. So a lot of times what we will do is, if a client comes to us and they're interested in selling their business, we'll start working on their data room immediately and making sure that they have already put together the various contracts that they have in a place that can be easily found and reviewed, that they understand the litigation that's outstanding, they understand tax issues, they understand all the nasty stuff about their business. So that's already in place, so that when the buyer comes in, they can move as swiftly as possible.
Speaking of cost, a lot of people have no idea about what the cost of an M&A transaction is going to be. Could you give a ballpark range? I remember there are a lot of people that think they're going to get their documents done on LegalZoom and it's going to cost them $500. But how much could it cost for somebody to go through a small to medium-sized transaction in their business?
It really depends on how much diligence is done, right? Then the sophistication of the parties on both sides, the amount of time that's taken over the purchase agreement, and whether folks are getting along or not, right? And so all of that negotiation and time, that's cost, right? You have lawyers working, you have accountants working, et cetera. I would say I'm seeing that the cost for doing these transactions is trending upwards, right? Inflation's pushing it up, but just the time and the complexity involved in an M&A transaction are pushing it up. So I would expect that you should be thinking around the ballpark of about $100,000 on the low end for doing a deal.
Wow.
If you're going to be using sort of, nationally recognized accounting firms, law firms, et cetera.
Yeah, it matters, because in the end, the main document, some people call it the APA or just the purchase and sale agreement or whatever it may be, that is the legal document that if you go to court, if there's something that you cannot resolve, it is going to legally spell out what happens. And I'm wondering, in your opinion, because I know these things can be 30, 40, 50 pages or more. Are there key things that somebody who doesn't have a legal background, i.e. an entrepreneur, what should they be looking at as core areas of that contract?
Interesting. Well, and that's what your lawyer's there to help you do. So you
need
won't be
one.
alone. Yeah, you won't be alone if you're doing it right. But I would say, one, you just want to make sure that the value you're receiving for the business, whether it's in cash or it's in stock or it's an earnout, reflects the value that you know that your business has. So that's number one. Number two is making sure that you look at what I call the indemnity section. So that's the part of the
indemnity section.
Right. That's the part of the agreement that says what you're responsible for after you sell if something goes wrong. If the representations that you make in this document are untrue, Here's how the buyer is compensated for it. If there are things that appear in your business that no one knew at the time of closing, here's who's responsible for it. That's all there in that indemnification section. I think those are two really important parts.
Robert, what about the piece that I know can get entrepreneurs really out of the seat of their chair? The two words I'm going to say here, or 4 words, is non-compete and non-solicit. Because if you sell a business, obviously there will be something to say you can't compete with this business, but also you can't solicit for the clients. Are there things that entrepreneurs should be watching out for? Is it customary that it is 50 or 100 miles? Is it customary that it's 2 years versus 5 years? Or are all these things all over the place?
So state law, and so it depends on where you are, but state law.
The state matters.
The state matters. The state matters. And then sort of traditional practice matters too, right? And also who you are and what you do.
Right.
So generally states will say, well, you can't keep someone from working altogether, right? And so there's a reasonableness that's got to be negotiated here. And so, and then there's a couple of different sorts of, compete restrictions. You can have a non-compete restriction in relation to your employment agreement. You can have one in relation to the actual sale of the business.
Oh, it could be both.
It could be both. And often buyers will try to get both, right? And so the non-compete or non-solicit restriction in relation to the sale of your business can often last longer than the one that you have in your employment agreement should you stay on. So
one final question in here. When you do set up a business, do you have a state of preference on where somebody sets it up? I always hear Delaware, Nevada, or other states, or does it matter if it's your home state? Because in the purchase agreement, if you have anything like arbitration, doesn't it matter where you put that in terms of the state that you might arbitrate?
So I would say this: when you're starting your business and you're conserving costs, et cetera, I would do it where you are.
Right.
And as I mentioned, over time, as you take in investors, you may have to make alterations to the business to bring in more investors, et cetera. Delaware is really popular. Everyone knows it. Everyone understands the law there.
Seems to be popular.
And so people often use that. New York is another one that's popular,
Really?
Particularly if you're bringing in outside financing to start your business. Often banks will want to use New York law because they're familiar with it and it's favorable to them. And in terms of arbitration, you often pick that based on where the parties are. So if you are in Georgia and all of your documents are based in Georgia and your buyer's in Delaware, often you can argue to just have it in Delaware, do your arbitration in Delaware.
Well, I wanted to thank you so much for bringing your time and your expertise here. I hope I'm not on the clock. But I bring this and hear about this business because, folks, at the end, when you're building this roadmap and you're thinking about starting and scaling and climbing the ladder and one day selling the business, your legal documents will matter, and getting the right representation may make the difference between you making a great transaction and one that fails. I'm Ted Jenkins. This is The Roadmap. You're watching us on the Atlanta Small Business Network. We look forward to talking to more about how to scale and climb the ladder and ultimately, one day, exit stage left.
Thanks for watching The Roadmap with Ted Jenkins. This has been a JBF Business Media production.